All right, everyone, it's my distinct pleasure to give Andrew an introduction here before we give him his warm welcome. Andrew Torrez founded his own firm in 2015 after nearly 20 years of experience in big firms in Baltimore, Maryland, and D.C. He focuses his practice on business litigation in Maryland and the District of Columbia. He represents individuals and businesses in complex civil disputes, including breach of contract and business torts, intellectual property, employment law, insurance coverage, and appeals before various state and federal appellate courts. He also has worked very closely with individuals, startups, and established businesses to provide counseling, advice, and other services with an eye towards minimizing future potential liabilities. He is a graduate of Harvard Law School with honors and George Washington University, summa cum laude. He is the co-host of the very popular Opening Arguments, the legal podcast that helps you make sense of the news. How many of you are listeners? Fantastic. Awesome. Me too. Please help me welcome Andrew Torrez.
Well, thank you very much. Thank you to the Lehigh Valley Humanists. Thanks to Jason. Jason is actually going to run my slides from back there, so I really appreciate that, and he really made this happen. And thank you to Martha and Richard Ciccelli. They are just fantastic hosts. You should check out the summer house concert series. You absolutely should. They're fantastic. So, I'm Andrew Torrez. I'm a lawyer, and I'm going to start this presentation with a couple of disclaimers. Number one, I'm going to talk about some political stuff here. And as a 501c3 organization, we all understand that I am not endorsing or encouraging you to vote for or against any political candidate or on any current or prospective piece of legislation, right? Good. Yeah. Number two, you understand I am giving this talk for educational and entertainment purposes only, and this does not form an attorney-client relationship, right? Don't take legal advice from this speech. All right. With that out of the way, we already did the show of hands of folks who listen to my show. For those of you who don't, it's a pretty good show. Give it a try, okay? I started Opening Arguments with Thomas Smith because Thomas and I are both atheists. We're both skeptics. And one of the things that we noticed is that skeptics there are some things that we tend to do really, 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 really well. And then when it came to the law, all of a sudden, there were things that we were not doing well. I think part of what it means to be a skeptic is really to be skeptical of everything. David Hume really put it more eloquently and more admonishingly than I would. He said, where men are the most sure and arrogant, they're commonly the most mistaken, and have there given reins to passion without that proper deliberation and suspense, which can alone secure them from the grossest of absurdities. You've noticed that the little puppy is in the corner for two reasons. Number one, everybody wants to see Lily, the Opening Arguments puppy. And number two, I'm about to beat you guys up a little bit, so I'm shamelessly trying to win over your affections by showing you that I have an unbelievably cute puppy. How about I continue with a little more pandering? Sound good? All right. Nobody here believes in a magic man in the sky, right? Okay. Oh, and by the way, since I know this is being recorded, this is going to go out to religious folks, and they hate that characterization. I want to point out, what I did was I went to Google Images. I pulled up filter by license, free to use even commercially. I typed in God. That's the first picture. There are about 35 more pictures that are just like that. So, and that magic man in this, that's your iconography, guys. So it's on you. No one here believes that vaccines cause autism, right? No one here believes that the Earth is 6,000 years old. No one here believes in homeopathic medicine. No one here believes that you should shove a jade egg up your vagina in order to connect the second chara, not chakra, chara, new word I learned, with your yoni, another new word. I don't know, to get optimal self-love and well-being. Okay. So that's all good. Everybody pat yourself on the back. You got those questions right. But I want to tell you something. Those are really, really easy questions, okay? Good job getting them right, but jade egg, come on, right? What Thomas and I noticed was people were getting these easy questions right. But all of a sudden, when it came to the law, they were getting it wrong. So I wanted to figure out why. So let's start with another thing we get right. This is the bacterial flagellum, right? And when J. Random Creationist comes up to you and says, the bacterial flagellum is an irreducibly complex molecular machine that proves it could only have been constructed by an almighty God, you know, your bullshit detectors go off, right? You know you're dealing with a fringe claim. And how do you know you're dealing with a fringe claim? You appeal to the consensus of mainstream science, right? Look, that's how I know this is a nonsense argument. Right? I'm not a molecular biologist, I'm a lawyer, but every molecular biologist has said that, that the whole irreducible complexity is a nonsense argument, and I apportion my beliefs to the evidence, and extraordinary claims require extraordinary evidence, and it's not there. Tell those same skeptics, however, that there's currently a petition for writ of mandamus before the Supreme Court that could nullify the 2017 election, force a revote, and allow us to put somebody else in as president, and all of a sudden you have a largely unnoticed and potentially landmark case. We could revote, guys. Now, February 12th, 2017. I'm not going to ask for a show of hands for who here reads a Daily Kos. I have included the URL. You can pull out your, go back. You can go back and you can pull out your smartphones. You can go to that URL. I pulled this page up yesterday. I need to tell you, a week after this full-page Daily Kos article ran, the Supreme Court summarily dismissed out this potentially landmark writ of mandamus. They did so in a procedure that did not require the government to file an opposition, which is a procedure the Supreme Court uses for complete and total cranks. They said, look, government, we don't think you even have to spend a minute of time, an ounce of paper, an ounce of drop of ink on refuting this nonsense, because obviously you cannot nullify an election and hold a revote. That's the stupidest thing I've ever heard. Okay. Do you think that next week the Daily Kos ran a full-page article retracting potentially landmark case? No, they didn't do that. But I tell you what is still there. This is another URL down in the corner. You can still go on, give $25 to Revote 2017, and Revote 2017 will send you a printed copy of their petition that the Supreme Court filed in the trash can without ever having to look at it. You can pull out your smartphones. You can go to that URL. I pulled this up yesterday. They're still taking my, although I will tell you, if anybody in here gives them any money, I will come over and punch you like a Nazi. Okay? All right. So why does this happen? Why do we have no problems dismissing the claims of Gwyneth Paltrow or those lovely, well-meaning young men up there who just want to tell you about how Jesus Christ came over to the ancient Americans, wrote down on gold plates how he was delivering steel swords and horses. I think that's how that goes. And look, I don't just have the Mormons up there for cheap laughs. I love the Mormons. I have them up there to illustrate a purpose. We know the jade egg up the yoni is false because of the claims of mainstream science and medicine. We know the claims of Mormonism, that ancient Israelites came to the Americas. We know that's false because of mainstream history and archaeology. But somehow, when it comes to mainstream legal consensus, well, that's just your opinion, man. I first got a sense of how hard this job was going to be on Thanksgiving Eve. About 8 o'clock at night, I was outside in my backyard. I have a lovely ceramic smoker. It's awesome. I was cooking a turkey for Thanksgiving the next day. Friends, family coming over. And all of a sudden, my phone started blowing up in my pocket. Now, my hands are covered in turkey right now, right? I've got to go inside and clean up and wash up before I can even touch my phone. And what was happening was I got about 500 messages because this was going on. Former Green Party presidential candidate Jill Stein had announced that she was seeking recounts in Pennsylvania, Michigan, Wisconsin. Okay? And if you add up the electoral votes in those 3 states, they just so happen to total exactly the number of electoral votes that would give Hillary Clinton the presidency. And she assured us that voter fraud in those 3 states, as a result of the recounts, we're going to overturn the results, take Donald Trump 306 to 260, Hillary Clinton from 232 to 278. Oh, and by the way, like the Revote 2017 people, would you mind kicking in a couple of bucks to support this? Now, who wants to know what questions were blowing up my phone that Thanksgiving Eve? Well, it'd be easier to tell you the question I didn't get, right? The question I didn't get was, gosh, Andrew, it seems kind of weird, right? If this is going to make Hillary Clinton president, why isn't Hillary Clinton bringing the lawsuit, right? Why is the lawsuit coming from that crazy lady who wished Harambe a happy birthday and got 1% of the vote, right? Like, I don't get it. That's not the question I got. Like I said, literally 500 emails, text messages. And the question I got was this. Andrew, is this real? And let me tell you what this question meant. Because the question did not mean, Andrew, is this real? The question meant, Andrew, please tell me this is real. For the love of God, tell me this is real. I can't have Donald Trump be president. I will do anything. I will believe anything. Just don't let Donald Trump be president, please. As it turns out, there's something those Jill Stein voters could have done to stop Donald Trump from being president. Okay? Those are the raw popular vote totals in the states of Wisconsin, Michigan, and here in Pennsylvania. In Michigan, Jill Stein got 51,000 votes. Donald Trump won by 10,000 votes. In Wisconsin, Jill Stein got 31,000 votes. Donald Trump won by 22,000 votes. And here in Pennsylvania, Jill Stein got 49,941 votes, and Trump won by 44,292 votes. Now, again, 501c3 organization. I'm not telling you you should have voted against Donald Trump in 2016. What I am saying is that if you were a Jill Stein voter in 2016, probably, I don't think I'm going out on too large a limb here to say, the last thing you wanted was to see Donald Trump get elected president. And mathematically, that's a pretty good argument. And you know, I think deep down, a lot of Jill Stein voters knew that. At least the ones I talked to. They said to me, look, Andrew, I went on 538 every single day. I looked at them and it said 92% chance of winning. And I wanted to vote for Donald. I wanted to vote for Jill Stein because Hillary Clinton was going to be president, and I wanted to send a message. And that's beyond the scope of this talk. We can talk about it in the Q&A if you want. But the last thing they really wanted was to make Donald Trump president. And so I think when the recounts came out, a lot of those Stein voters said, okay, I made a mistake, but now I can fix it, right? There's got to be something I can do. I screwed up. I'm sorry. I can fix it, right? They're like Homer when he loses the pig de resistance, and he says, it's just a little dirty. It's still good. It's still good. It's just a little slimy. It's still good. It's still good. It's just a little airborne. It's still good. It's still good. It's gone. Yeah, I know. Even Homer comes around to acceptance. OA fans in the audience, you knew you were going to get a Simpsons reference, right? So, it's that moment, by the way, that when we're in the position of saying, it's just a little airborne. It's still good. It's still good. That's when we become the least skeptical. That's when we want something to be true more than we care whether it's false. So that night before Thanksgiving, I cleaned up, finished out the turkey, went in, recorded an emergency episode of Opening Arguments, got on Twitter, got on Facebook, and I said something that made me very, very unpopular with a lot of people who liked my show and otherwise agreed with me politically. I'm pretty left of center, right? And what I said was this. I said, I'm a lawyer, and this is Michigan's election law. It's MGL 168.862. And it says, candidate for office who believes she is aggrieved on account of fraud or mistake in the canvass or returns of the votes may petition for a recount. And I said something really, really simple. Aggrieved is a legal term. That means the court has to be able to do something about it. That means after the court does something, your position changes materially. Jill Stein was at about 1% before the recount. She was going to be at about 1% after the recount. And she wasn't even claiming that she was going to be at 5% or change. It was in fourth place. She was going to stay in fourth. She was claiming it was going to benefit Hillary Clinton. That doctrine is a doctrine called standing. I want you to remember that word because it's going to come up a little later. But you don't have to be a lawyer for the bacterial flagellum bullshit detector to go off. For you to sit there and think, gosh, I am familiar with courts, and usually speaking, courts redress individual problems, right? They don't issue advisory opinions. They don't just opine about the law into the air. They take somebody who's been wronged and they fix the wrong. And if they can't fix your wrong, you don't have standing. There's nothing for the court to do. Okay? So I made that point, and then a listener who was also a lawyer said, she added me to a Facebook group called Lawyers on the Left. She said, you got to come on to this Facebook group because there are like 30,000 lawyers on there, and they're all saying we should be donating money to Jill Stein. I'm like, all right, fine. So I went on, and I made a really, really short post in which I explained the standing argument that I just explained to you. And again, this is lawyers on the left, right? Right. So I then got a comment on the post from one of the administrators of the group. And the comment said, Andrew, if you're a lawyer, you know as well as I do that you can never predict what a court's going to do. So I view this kind of like a lottery ticket, and I'm willing to give Jill Stein my money and just hope for the best. And I wrote back and I said, well, see, that's the difference between the two of us. I wouldn't advise you to play the lottery either. And that ended my very short tenure on the Lawyers on the Left Facebook group. You guys know how this story ends, by the way. The Michigan court said Jill Stein has no legal standing because she isn't agreed. Okay. In Wisconsin, Jill Stein's recounts actually resulted in Donald Trump gaining 131 popular votes. And here in Pennsylvania, you may recall this was a bit of a story. Despite the fact that Jill Stein raised $7.5 million on the recount, her lawyers on her behalf refused to post the $1 million bond, claiming that she represented, quote, regular citizens of ordinary means who couldn't afford it. Talk about that in a minute. My point in bringing this up is not to say, I was right and you should, because I'm smart, because it is not surprising that I was right. It is not impressive that I was right. The dumbest lawyer on earth would have been right in this, okay? Because anybody who thought about it for a second would have said, courts don't exist to redress imaginary grievances. They exist to solve problems. You don't have standing. You might wonder about Wisconsin, by the way. They have a specific recount law that says any candidate may request a recount. That's kind of weird. It was one of the things I looked up first before going through and posting my screen, because who knows, maybe all 3 states had that weird law. They didn't. You saw the Michigan law. Jill Stein posted a disclaimer on her website. This was then later taken down, so this is a screenshot that I took at the time. The disclaimer says, we cannot guarantee a recount will happen in any of these states that we're targeting. And if you read through, it basically promises to maybe spend the money on possibly filing for a recount that maybe we'll do. And then if not, at the end, any money that happens to be left over will be spent on election integrity efforts and to promote systemic voting system reform. By the way, nice use of system twice in a phrase. That's a Green Party buzzword. It's on page 1 of their platform. It's been something they have wanted to do since time immemorial, which is get ranked preferential voting in election, which they don't have a chance in hell of getting, but would help third parties. And I'm not saying it's a bad idea. It would help third parties and fourth parties and fifth parties. But what this means is that was a fundraiser, right? And you don't have to take my word for it. This is Jill Stein's own page, mostly, of where the money went. You'll see the little Jill, 2016 in the upper left-hand corner. They raised $7.5 million. They spent $2 million on the Green Party's own lawyers. They did about $50,000 worth of work, so I don't know where that other 1.95 million. $300,000 on media, $200,000 on travel, $200,000 on staff. There's $4.5 million in filing fees. I know we have at least one lawyer in the audience. That seems a little weird to me, but none of that is why I have this slide up here. I have this slide up here because if you look at the bottom, it says, once the court cases have been completed, the remaining funds will be distributed to Green Party voting justice initiatives as determined by a ranked choice vote of the donors. It's fundraiser. And in case you're wondering, throughout the entirety of the Jill Stein for President 2016 campaign, she raised $3.7 million. So the recount fundraiser in 2 weeks raised twice as much money as the Jill Stein for President fundraising raised in 2 years. Now, I do not have a problem. If anybody in here is a philosophical Green Party voter, I have some problems with you strategically, but I don't have a problem if you want to give money to Jill Stein. I don't have a problem with Jill Stein wanting to raise money, wanting to raise visibility for the Green Party. I have a problem when you have a fundraiser and you call it a court case. I have a problem when you lie to people. So, the Jill Stein story doesn't piss you off as much as, let's say, these guys who offer copper magnetic therapy bracelets that will cure arthritis, carpal tunnel, and depression. Then you're doing skepticism wrong because that thing only costs you $25. Whereas the 160,000 Jill Stein recount, no, we'll go back. Whereas the 160,000 Jill Stein recount voters each gave an average of $45. And this, you actually get a bracelet. Look, it's 99% pure solid copper, right? The magnets are encapsulated for extra protection. I think that balloon says that it's ribbed for her pleasure. It doesn't matter. Like, the point is, right, you get the bracelet when you're done, right? The people who donated to the recount got nothing. So, how did this happen? Again, I think this happened because there was a lot of motivated reasoning going on. And keep in mind, what plays in with motivated reasoning is this case had political implications. And I've already told you about how left-leaning sources like Daily Kos and worse, like Occupy Democrats, were reporting favorably on Jill Stein's recounts. And people tend to be less skeptical of the news reports that agree with the political biases that they take into the process. That's not unique to the law, but it's really, really important in the law. It's why I'm up here and why I'm bashing on the Green Party and Daily Kos and Occupy Democrats. Don't go to Occupy Democrats, by the way. That's just don't. Because I'm a lefty guy, and I need to be skeptical of the sources that I agree with. That is in no way meant to suggest that on the right there is not an equal or worse problem. And in fact, I don't have the time in this speech, but one of the episodes that we did on opening arguments is we revisited the McDonald's hot coffee lawsuit. And suffice it to say, everything you've ever heard about that lawsuit is almost certainly incorrect. And it's incorrect for a really, really simple reason, and that is plaintiffs' trial lawyers. And by the way, I'm a defense lawyer, so these are the people I'm opposite. But plaintiffs' trial lawyers tend to be Democratic Party donors. And so the Republican Party has a vested interest in convincing everybody that plaintiffs' trial lawyers are greedy, shiftless, immoral jerks, and that every case they bring is meritless. And they picked the McDonald's hot coffee case, and they did a fantastic PR job of convincing people that a totally meritorious and in my view, the damage award that was awarded in that case was grossly insufficient to cover the facts of that case. But again, we can't go through that now. What we can do is kind of talk about these areas where public understanding of the law breaks down. So we talked about motivated reasoning. The second area where I think people get taken in by fake news, by misleading legal stories, has to do with the fact that the law uses a specialized vocabulary. And so people come to think of the law as these like crazy words in Latin that have to be put in the right order. And if you don't have the magic wizard, then the spell doesn't work properly, right? So this is actually a deed, a short-form deed for the sale of land in the District of Columbia. And if you look through, you'll see some of that like specialized language that I talked about, right? Like if you look through, you got the witnesseth, the parties of the first part do hereby grant to the party of the second part. Like, what is that like crazy ye olde English stuff in there? And it's really there. But it turns out there's a reason. There's a good reason for why. Sorry. There's an incredibly stupid reason for why that language is in there. But there is at least a reason, right? And that incredibly stupid reason is real property law is a function of, it's a common law doctrine, right? And so we inherit it from England, and England inherits it from 11th century Saxony, and you're left with witnesseth and... Okay, so I get it. So there are areas of the law that require this sort of arcane and specialized vocabulary. And in fact, some of the work I do today still requires that arcane and specialized vocabulary when it comes to specific things. But I want to tell you that it's getting better, right? So if this were the 19th century, if this were the dawn of the 20th century, we would have something called the forms of action. And what the forms of action meant was when somebody did something wrong to you, I stole your wallet. You want to get your wallet back. It was not good enough for you to go into a court and say, Andrew stole my wallet. You had to go into a court. You had to pick the right court based on the relief that you wanted. So if you wanted to get the wallet back, you had to go to a court of equity. If you wanted to get the money back, you had to go to a court of law, right? And when you were in that court, you had to use the right magic words. And I'm going to read some of these to you, and I actually have to read it off the slide because these words are amazing. A writ of right, an assize of novel disseisin, or of mort de ancestor. I think I know what that one means. A writ of entry sur disseisin in the per and qui. A writ of besail, of quare impedit, an action of covenant, debt and you, replevin, trespass, assumpsit, ejectment, case. I cannot tell you what 2/3 of those words mean. And I don't have to, because about a century ago, all the lawyers in the universe, well, all the lawyers in this country got together and we passed this, right? This is Federal Rule of Civil Procedure number 2 now. It is 9 words long. And it says, there is one form of action, the civil action. So all of that like crazy mort de ancestor, assumpsit crap, that's all gone. And in fact, this is Rule 2 because Rule 1 says it should be construed liberally. And so what that means is you can take a napkin. You can take a bottle of pink nail polish, and you can write, Andrew stole my wallet, in pink nail polish on the napkin. You can spell it like Eli on crack, and you can go to the court, and you can file it, and the court will date stamp your napkin, and they will file your case, and they will take it seriously, and you will have your day in court. We're trending away from specialized vocabulary towards fairness, towards simplicity, towards reasonable and meaningful interpretation of the law. So what does that mean? It means when you see an argument that relies on arcane words, that says you have to say this in this right order, and if you file a UCC1 in this, be skeptical of that argument. It's not to say it might not be correct. There are some things, I don't want to oversell it, but it is to say the law is not about crazy words in Latin that you have to get right and say in the proper order. The third issue that comes up is ambiguity and equivocation. Lots of legal terms have multiple meanings. This is a doozy, so strap in. Okay. This is an actual screenshot from a website. The website is unlimitedtruthseekers.com, and out of kindness to you, I cropped it. That purple, I did not want to be liable for anybody having a seizure. Here's the argument, and I promise you, I am not kidding about this argument, okay? The argument is your birth certificate has your name in all capitals, not because that's how typewriters worked back then, but because it is secretly a corporate entity, and it's not a real person. That corporate entity is the beneficiary of a negotiable instrument which the United States has pledged as collateral to a shadowy cabal of international bankers. That always means Jews. As collateral for the debt that the U.S. acquired in 1933 when they secretly declared bankruptcy and went off the gold standard. I am 100% not making this up. Promise you. Okay? Thousands of people believe this. They issue fake UCC-1s to each other in order to try and get the billions that your birth certificate owes. I want you to see in that upper left-hand corner, see it says, take back your straw man. I cannot go through what they mean by straw man. It's just, it would require hours. But enough peeve this. This is a warning, maybe it's warning. This is a warning from the FBI. Redemption, straw man, bond fraud. So many people believe this argument that the FBI has had to post it to their page. How does this happen? Well, obviously there's some motivated reasoning going on. I mean, I could use $1 billion. I don't know about the rest of you. But there's also that motivated reasoning doesn't quite get you over the hump when somebody's trying to convince you that your birth certificate is a magic key to the bank vault's worth, right? You've also got to have legal argument now. And so here's some of the legal arguments that these people use. And again, I am not kidding, okay? So the first one is, look at your birth certificate. Look at the bottom of your birth certificate. It says banknote. Why would it say banknote on it if it's not a banknote? Now, you're not swayed. I see some skeptical eagle eyes in the audience, and you realize that says American Banknote Company. Again, I've taken this from an actual tax protester website, right? American Banknote Company. And the wheels might be turning, and just like how AT&T stands for American Telephone and Telegraph, even though the telegraph part is, right, exactly. American Banknote Company is a company that was started in 1795 as a government contractor, and what they make is tamper-resistant paper. Today, they are a subsidiary of AB Corp, a multinational conglomerate that provides tamper-resistant paper. And so what did AB Corp, what did the American Banknote Company do? They were contracted by the federal government to issue the paper on which we print the money, on which we print government bonds, and on which we print your birth certificate. So that little American banknote at the bottom of your birth certificate might as well read International Paper or Kimberly-Clark or Boise Cascade. It's literally the paper company name. If you're not persuaded by the banknote argument, maybe you'll be persuaded by this argument, okay? Did you know that the legal term that the Oxford, both the Oxford New English Dictionary and Black's Law Dictionary define certificate as a document issued by a bank in return for a deposit of money which pays a fixed interest rate for a specified period? That's actually true. I mean, it's true for the certificate of deposit definition of certificate. It's not true for birth certificate, obviously. You can also do this one, right? If you go, and I don't have the slide for this, I'm sorry, but if you go to law.com and you type in register, R-E-G-I-S-T-E-R, then it will bring up a filter box. And if you type in registered with an ED, I got all these instructions off a crazy sovereign citizen website. That's how I found it. If you type in registered with an ED, it filters the result down to just one word, just one legal term, bond. And that means when your birth certificate is registered, you are actually bonded to the government and you're put into perpetual slavery and they've taken all your money and somebody can help you get it back. And you know who can help you get it back? This guy. That, by the way, he just named himself judge. He's not actually judge, right? For the low price of $250, he will issue to you an international bill of exchange. It's an affordable fee, that's what he says, right? And he's pretty sure that your local bank will take that international bill of exchange and let you withdraw at least $2 million per year for the next 50 years tax-free. I think my favorite part of this whole thing is the at least part. Like, whenever I go to the bank, I always ask to withdraw at least $50, and, maybe they give me more. This seems pretty easy and pretty crazy. But I want you to remember the FBI warning. I don't know how many people have given Judge Naidu here, $250. But enough people have done it that the FBI has issued a warning. And I want to tell you, I've picked an obvious claim here because the next one you encounter might not be so obvious. Lots of bad legal arguments depend upon equivocation, using a word out of context and telling you, oh no, it definitely means this, in order to lead you down the garden path and convince you of a proposition that is preposterous and crazy. So what do we do about that? Well, you should be skeptical of any argument you hear about the law that relies on definitions. Right? I'm not telling you lawyers never cite to a dictionary. Okay? But by and large, if we have a principle that we want to explain, we're going to cite to cases, to a line of cases. Now, that causes its own problems because plenty of crackpot arguments have a crazy citation of lots and lots of cases. And how do you figure that out? And that's problem number 4. It's the problem of incomplete information. And I'm going to do my best here. Paula's excellent talk at the beginning referenced the school desegregation cases. So hopefully everybody in the audience knows the case of Plessy versus Ferguson, right? Plessy versus Ferguson is the 1896 case that held separate but equal is fine and does not offend the 13th and 14th Amendments. It was overturned by Brown versus Board of Education in 1954, so it hasn't been good law for 6.5 centuries. And what I have side by side here are 2 different things. On the left, I have the Plessy versus Ferguson that you see. You go to Google Scholar. Again, you take out your phones, do it right now. I won't take offense. Type in Plessy versus Ferguson. It pops up the one on the left. On the right is what I get when I put Plessy versus Ferguson into LexisNexis. Can anybody spot the difference between these 2 things? Yeah, okay. Mine has a giant red stop sign on it, right? And that stop sign means what it looks like it means. It means, Andrew, if you cite this case, opposing counsel and the judge and all of her law clerks are going to laugh at you because this case hasn't been good law for 6.5 decades. Stop. Stop, you moron, stop. But your Plessy doesn't have a stop sign. Now, nobody on earth, well, maybe Jeff Sessions. Nobody else is going to cite to Plessy versus Ferguson. I picked an easy one to help illustrate the principle. Some of you may know, listen to my show, I had a layperson on to discuss the lawsuit brought by Ann Coulter, brought by the Berkeley College Republicans on behalf of Ann Coulter and other conservative speakers at Berkeley University. And the person that I had on was citing to a case that had a giant red stop sign on it. And I was trying very gently to explain that this case had a giant red stop sign. And by the way, it was from the Fifth Circuit, which covers Texas, Louisiana, and Mississippi, and not at all California. And by the way, he was citing from the dissent. And you guys know the dissent is the side that lost, right? So the point isn't, right? Like, my heart went out to this guy because I realized that his information was incomplete. He didn't know. He didn't know that the Fifth Circuit had withdrawn 99% of the opinion. He didn't know that the Fifth Circuit doesn't govern in California. It's not his fault. But there's a little bit that was his fault, okay? And that was, it was clear that what he had done was gone into Google and searched for, are speaker fees unconstitutional? And then found a case that seemed to kind of say that, right? If this were science, this were medicine, this were history, we wouldn't have any problem figuring out what's wrong with that. You don't start with your conclusion and then cherry pick the data that supports it. But because it's the law, because it's just your opinion, man, that's how people sort of work backwards. So this is a tough one, okay? I won't lie to you. But I can give you some tips to try and help not fall into this trap. And one is kind of basic, okay? And that is, I'm going to tell you as a lawyer, for general concepts, Wikipedia isn't too bad. And I have my suspicions as to why I think it's not too bad. And that is because lawyers are pedants. And so when we come across a Wikipedia article that says something egregiously wrong, we get in and edit it. And so what you're left with is, if you look up general legal principles in Wikipedia, you type in standing, freedom of speech, separation of church and state, cruel and unusual punishment, you will get a decent overview, right? Don't take legal advice from Wikipedia either, but what you'll get is an understanding of the concept, and then it will list the major cases, and then you should go tackle those cases, okay? But you shouldn't try and reason from language in the case back to your conclusion. You try and understand the general principle first, and then work from there. And I want to add one of the things that is very, very easy. You see this kind of motivated reasoning. Every tax protester argument, and I've kind of alluded to this, but the birth certificate thing is sovereign citizens who think that they don't have to obey the law, and there's a secret pot of money, and you get it from the international bankers. And tax protesters are a subset, they're kind of related, who say you don't have to pay taxes. And they often start with a citation. Every crazy tax protester website that I've ever seen starts with a citation to a case in which the Supreme Court said the government has no power to engage in the levying of personal income taxes. Actual real case, actual Supreme Court actually said that. Okay? The only problem is the Supreme Court said that in the 19th century, and we amended the Constitution in 1913 with Amendment 16 that authorizes the income tax. You don't get that when you're on the tax protester website. Yeah, I'm riffing a little bit, Jason. I know it's off the script. That's something you can figure out, right? When you see a citation to a case and it doesn't contain the court, the year, hopefully in an actual, one of the things I try and do in opening arguments is I give you the reporter number. And I do that not just to sound lawyerly, but kind of maybe, but also because when I tell you a case is 508 U.S. 237, you can go to scholar.google.com and you can type in 508 U.S. 237 and you can pull it up. And I want people to, I link the case in the show notes, I want people to do this sort of thing. And when you see a string of cases that either don't cite to the court, have incomplete information, or if you see the Supreme Court said this, and then this court in New Jersey said this, and then this court in Wisconsin said that, think to yourself, maybe somebody is cherry-picking quotes and putting them in the wrong order to try and lead me to a conclusion. The incomplete information problem it's a real problem, and I can't get you through everything, but I can hopefully get you through not sending $250 to Judge over there. So now on to problem number 5. I'm going to do a Marco Rubio for a second. I apologize. Problem number 5. Sometimes the law leads to counterintuitive results. And again, this is true, but largely overstated. So these 3 headlines here are literally the first 3 headlines that popped up when I typed in lawsuit overturned by technicality into Google News. I could have put 1,000 up there, right? We know the story. And if you've ever watched a cop show, a lawyer show, a movie, whether it's lawed awful or not, you know the story of the technicality, right? Which is, the facts are clear. It's totally obvious we should get to this result, but the court has to come to that result because of that damn technicality. It makes for great drama, and the reason that it makes for great drama is because it lets you present a clear sort of black and white moral choice. The fact that it's such good drama leads us to believe that this kind of stuff happens all the time, and the reality is, A, it doesn't happen all the time, and B, when it does happen, there's usually a reason for it, right? Sometimes not a great reason, but usually you can figure out why there is the technicality in the first place. So let's start with, I think it's the upper left-hand corner, statute of limitations. Okay, statute of limitations in the civil arena, it generally means you have to bring a lawsuit against somebody who has done something wrong to you within 2 to 3 years, depending by state, by cause of action. Okay, and so there's a technicality aspect of that, which is if you steal my wallet, and I know it, but it takes me a while to bring the lawsuit, and it's 4 years later, I can't bring the lawsuit, even though I know you stole my wallet, even if the facts are clear, right? And that seems unfair. The statute of limitations just provides a hard date, cuts off your cause of action. But I'm going to tell you there are two good reasons for a statute of limitations, right? First, particularly in the civil area, is because defendants deserve the right of peace of mind when somebody has threatened a lawsuit to know that that threat is no longer good. They deserve to know when they can rest easy, right? And I'll give you a real example, real case I have right now. A client of mine is an accountant, and he has a client of his who is threatened to sue him over the preparation of his tax returns. And so that client hired a lawyer, wrote a nasty threatening letter to the accountant and said, we're going to sue you and we demand, blah, blah, blah. So he hired me, and I read the letter and I looked over and we looked at the facts, and I wrote back a response letter that said, you're wrong on the facts and you're wrong on the law, and we'll offer to settle this case for, minimal amount. Thank you very much. That was 3 months ago. I haven't heard back. Right? I think it's probably not likely that the lawyer's going to file the lawsuit because he's wrong on it. But when my client calls me and says, hey, Andrew, am I going to get sued on that thing? My answer has to be, don't know. Probably not. And he's like, but I got to save up money if I'm going to get, yeah, right. A year from now, I will be able to tell him with finality, nope, can't be sued. You can rest easy. Right? I think that's a pretty good reason to want to cut things off. In the criminal area, the reason is not usually focused on the defendant because we tend not to care about the rights of defendants in this country. But it's focused on the fact that really, really hard to prosecute old cases, right? Evidence degrades, disappears, witnesses become unavailable, which is to say they die. So even a lot of crimes have statutes of limitation, but there are limits to that. For example, there's no statute of limitations on murder. Most states have no statutes of limitation on child sexual abuse. Okay? So even where there are arbitrariness, even where there are points that cut off your right to seek justice in the criminal system or to seek recompense in the civil system, there's usually a reason, and it's usually tempered by other social considerations. And so, where am I? I've kind of gone off my script a little bit here, but another area where we tend to think of the law as producing counterintuitive results is in the area of the exclusionary rule. And if anybody here, fans of cop and law shows and dramas, you know the exclusionary rule. The exclusionary rule as a principle says this: if the police illegally search your premises and they discover a piece of evidence, they should be prohibited from using that piece of evidence and anything that flows from it in the case against you, right? And we do that. We have the exclusionary rule. That rule is only 50-odd years old. It's a judicially created rule. The reason we have that is because before we had that rule, we realized that nothing but that rule would deter the police from illegally seizing evidence, right? Like previously, you could bring a civil lawsuit against the officer for, and that works real great when you're an indigent defendant in jail suing a police officer, right? So the only way to deter police officers from illegally seizing the evidence was to say, if you've illegally seized the evidence, it can't be used against you. And remember that illegally seizing evidence without a warrant, that's a foundational grievance to the founding of this country, right? That's one of the reasons we're not the, province of Great Britain right now, right? But even in the exclusionary, so the exclusionary rule is another one of these that kind of pushes our buttons, right? Because you'll watch the trial unfold in a movie or in court TV reporting a real case, and got the bloody knife, but they can't introduce the bloody knife into evidence. And so the jury comes back and they, there's a finding of not guilty and the defendant is acquitted, and you look at it and you go, well, I'm pretty sure if the jury knew about the bloody knife, they would have come to the other result. And it seems counterintuitive, and it seems wrong, and it pushes our buttons. But as it turns out, exclusionary rule has an awful lot of exceptions to it. One of the exceptions, major exceptions to the exclusionary rule, is the doctrine of inevitable discovery. And what that says is, if the prosecution can show that they would have discovered that bloody knife without searching illegally, then they can introduce it back into evidence again. And we're all in the land of what if and make-believe, and I will tell you, you talk to any prosecutor or any criminal defense lawyer, and they will tell you that the exception of inevitable discovery has more than swallowed the rule of the exclusionary rule. So ultimately, the lesson here is that these kinds of technicalities are, they're really, they're sexy. They push our buttons. They make for a good story. But they're not very common. And when there are exceptions, they're almost always tempered by a social reason for that exception. If you are listening to a legal argument that relies on a series of embedded technicalities and says, I know this, but if you file the UCC1 in the bottom right-hand corner, you're probably not listening to a good argument. I'm going to tell you a little bit of a story of a real case that I litigated. That in the upper left-hand corner, that is what used to be known as the First Mariner Arena in downtown Baltimore. Alice knows this. The First Mariner, it's now called the Royal Farms Arena, and it's a 15,000-seat indoor venue. And my client owned the Baltimore Blast, which is an indoor soccer league team. And you are probably suspecting that indoor soccer is not a billion-dollar enterprise. And in fact, most indoor soccer teams are sort of barely breaking even or then some. And so it's kind of best practice within the industry of indoor soccer to have exterior billboards on the outside of the home arenas in which the teams play, and then you get the money from the billboards, you split it with the city and the management company and the soccer team, and that helps get them any revenue they can in order to stay afloat. Now, you may feel one way or the other about having an indoor soccer team and whether that's worth it, but what my client did was said to the city of Baltimore, hey, look, every other city where we play indoor soccer, they have these billboards, we don't have these billboards, we should have these billboards or else we're going to relocate the team to a city that has the billboards and maybe make some more money. So the city council went out and passed two pieces of legislation. It was actually three. I'm not going to get into the specific lawyer jargon on that. But they passed a series of bills all at the same time. Because Baltimore has a comprehensive ban on billboards throughout the city. That comprehensive ban is a safety ban. If you've driven through a city that has a highway that goes through it and that has these big billboards that overhang, that people look up at the billboards and they steer, and they crash their cars. So Baltimore bans billboards throughout the city. So what the county council, what the city council had to do was authorize a special exemption and then grant that special exemption in favor of the First Mariner Arena at the same time. They did that. Then we were immediately sued by Peter Angelos, the owner of the Orioles. And we were sued because prior to the billboards going up, the only exterior advertising available in the city of Baltimore was in the walls at Camden Yards. And the supply and demand, like the price for billboards in Camden Yards went down. Right, exactly. So Peter Angelos sued us. I litigated this case for 8 years. 3 companion cases. I litigated at every level of the Maryland courts, from trial court to our Intermediate Court of Appeals to our state Supreme Court, which is called the Court of Appeals. It's a little confusing. That's the citation down there in the corner. You can actually look it up, and I highlighted my name and all that good stuff. Peter Angelos' argument was, this seems kind of fishy. This stinks. How did they get the exception and the authorization on the same day if there wasn't a crooked deal? And that was it, really. I mean, I'm oversimplifying, you can read the case. But the argument was, this isn't fair. And you know what? I had to take that argument seriously for 8 years. I couldn't go into court and say, well, tough noogies, Peter Angelos. Law says this, and so we're going to do it. Because the court said that the judge was interested and leaned forward and said, Mr. Torrez, how do you answer this fairness consideration? And the fairness consideration that he brought up was, what's to stop the city from granting a special exemption use next to your house and putting in a hog rendering facility, right? And there's a complicated legal answer that would stop that, that I am not going to get into right now. You can ask it in the cross-ex if you want. But I had to take that seriously. I had to say, this will not, Your Honor, lead to placing hog rendering facilities next to people's houses. This will be fair. And in fact, if you read this opinion, I win on the law, but they remand it back to the trial court to allow him to amend his proceedings to raise another. Like, the courts took that argument seriously. And the reason I went through that whole history here is because I want you to understand courts take average fairness considerations seriously. And so if you're reading something and it is predicated on something that seems grotesquely unfair, give it a second read through. Because I'm telling you, as a lawyer, other lawyers in the audience can back this up, that fairness concerns do matter, and that the strict letter of the law, yeah, sometimes it wins out, but sometimes it takes you 8 years because the other side says, this stinks. And that's really the lesson here. So here's how I would sort of summarize my takeaways. I see some of you are flagging. I tried to make this fun, but I know it's been a long time. Number one, when you're reading a legal story, when you're reading anything, try and be aware of your own biases so that you're not engaged in motivated reasoning. I think that's pretty clear. Number two, look for the context to try and understand concepts, general legal principles. Don't be swayed by isolated quotes by dictionary definitions. Number three, recognize that the law is moving away from technicalities towards simplicity, and the courts will always ask, is this fair? And then number four, read the source documents. And I suppose I should put in a plug for number five, which is listen to my show. we do this twice a week. Anyway, thank you all very much for being attentive. I really appreciated this opportunity. So let's do some questions.
So for the Q&A, we like to give people the mic so that on the YouTube video that comes in later, that everybody can hear the question without Andrew repeating it before he answers. So if we got hands for questions, I can bring the mic around. We got Kate over here.
Hi, thank you so much.
Oh, thank you, Kate.
You're very good at explaining things in a succinct, easy to understand way, and I'm hoping that maybe you can help me figure out an explanation for something that I have to talk about all the time at work.
Okay.
So I do a lot of birth control counseling at my job, okay? Mm-hmm. And at least once a week, I have a patient who stops taking their birth control or refuses to entertain a certain method of birth control because of the class action lawsuit commercials on TV that tell them that something is dangerous, or if you've taken this, call right now and get in on this lawsuit. And people are, this scares the bejesus out of people. And I was wondering if you feel like this is enough of your area, if you could give me a recommendation on what do I say to these people to let them know how to interpret this as, I'm imagining, probably garbage.
Yeah. Let me do what I always do with these kinds of questions, which is I'm not going to answer the question specifically,
okay,
but I'm going to talk about a bunch of other stuff, and you're going to think that I've answered the question by the time we're done.
Perfect.
Okay?
Perfect.
So I'm going to start off with a lot of other commercials that you may have seen to sort of illustrate the point. So how many have seen the commercials for asbestos personal plaintiffs injury lawyers that say, if you have mesothelioma, right? Yeah. So why do you think they specify mesothelioma? Okay. The answer is because it used to be that you could bring asbestos cases for something that was called asymptomatic asbestosis. And that asymptomatic is really the key part, right? Like people who had no symptoms, they used these people named B readers, and I'm not even going to go into all that. People who had no symptoms were being signed up by plaintiffs, personal injury lawyers like Peter Angelos, and they would round them up in vans at work sites and tell you, if you sign this piece of paper, we'll include you as part of, they weren't even class actions, they were just mass settlements, and those people got $500, but if you aggregate tens of thousands of people together, you can become wealthy enough to own the Baltimore Orioles. And so I did an insurance case that involved, this is why I'm riffing for this long. I promise I will get back to the actual question. And we looked back at the state of projections of asbestos liabilities in 1973. And there were a couple different models. There was an epidemiological model, which sort of did this, and there was a previous litigation model, which sort of did this, and there was an academic literature model, which sort of did this. And then we overlaid on top of that graph the actual model. 1973 was the first asymptomatic asbestosis case. And the actual model was that, right? Because when you essentially have a license to commit fraud for millions of dollars, people will do that. And so as these cases, and by the way, plaintiffs' asbestos cases, particularly in the 1970s and 1980s, are what the Republican Party would have you believe that all plaintiffs' personal injury cases, there's some. So most states, in fact, I think every state now, has passed asbestos reform acts that the only cases that are getting out of these giant multi-district litigation holding pens are cases that involve mesotheliomas, because mesothelioma is cancer, it's a real illness, and we really want those people to get the money that they're entitled to. So the reason that the lawyers advertise, if you have mesothelioma, because mesothelioma is a rare commodity, and they want those people to sign up because they've got tens of thousands of people who are like, well, I used to work down at the plant and I cough from that. You know, they're not worth anything to the plaintiff lawyer. The mesos are worth something to the plaintiff's lawyers. The other thing I do, you heard from Jason on the intro, is I work with a lot of small businesses on wage and hour law, Federal Fair Labor Standards Act practices. This is an area, I did a two-part episode on OA. It's an area that I think is going to explode in the future because of some unique aspects of the law that I can't quite get into right here. But I always open the talk I give on the FLSA with the same kind of show of hands. How many people have seen the commercials from the plaintiffs' firms that say, were you forced to work overtime and not paid for it? And they advertise in Baltimore during Monday Night Football games. There's a firm, a very well-known firm that does that. And then my second question is always, how do you think they can afford to advertise during Monday Night Football? Right? And it has to do with, again, another weird contortion of the law on that. So, all the way back around to your question, the reason that you have that level of urgency in those commercials with respect to, have you been injured by, is because it's incredibly rare, and because you're a rare commodity to those plaintiffs' personal injury lawyers. And remember the second half, which is something all lawyers know and almost no non-lawyers know, which is when there's a disclaimer on something, when there's a warning on something, that's meant to protect the company. That's not meant to inform you, right? So I don't know if anybody here is a smoker. If you look at your pack of cigarettes, right, there's the warning, the Surgeon General. The cigarette companies lobbied for that, right? The cigarette companies want there to be a warning on the cigarettes that says this is hazardous to your health, so that you can't sue them for because they're going to be like, well, look, like we tell you it's hazardous to your health, right? So put the two of those things together, I would say, which is, number one, the disclaimer is meant to protect, because you're asking about the lawyer commercials, but I imagine they also see the commercials with the like happy people skipping through the fields, and at the end they're like, this product contains a huge risk of death, and that's on there to protect the company and,
right,
and not them. So I hope that kind of answers, sort of.
It does.
Oh, good.
Yeah.
No one ever says that to me, so thank you very much.
Okay, in the interest of time, I want to take a couple more questions, but I want to limit to people who are not coming to brunch with us, since Andrew will be there and you'll get more time to talk to him. Is there anybody who's not coming to brunch that has an additional question? Yeah?
Hello, thanks for your talk. Big picture question. It seems like our nation and our states are, to a great degree, being manipulated by the more conservative representatives, called gerrymandering, the Electoral College and its historic, role in playing out in, especially this last election. What effort, from your point of view, might give us a practical path forward to resolving, fair representation and perhaps a progressive path forward?
What's your name?
Brian.
Brian. That is an excellent question, and I'm going to do the same thing, which is I'm not going to answer it, but I'm going to talk about all sorts of other stuff that makes you think I get answered. Okay. So first, I've done. On the episode on opening arguments, I've done 2 episodes about gerrymandering. I think that it is the number one problem that we have in our political system today. There is presently a case pending before the Supreme Court from Wisconsin that provides a mechanism for the court to authorize lawsuits that challenge districts on the principle that it violates one person, one vote. It's therefore violative of due process. I'm not super optimistic about that case for a lot of reasons, for one that I go into on the show. But I'm going to describe the problem a little bit. Jason, Martha, and Richard will recognize this from last night. The House of Representatives is intended to be the most responsive branch of government. Right? That's why they're elected every 2 years. It's why they're constantly running for office. And what we have right now is we have a president, and again, 501c3, I'm describing a historical occurrence. This president is between 36 and 39% approval rating. Historically, what that would mean is that people in his own party would be defecting right now. That's not happening, and the reason that's not happening is because when you look at that graph on the last poll was a Quinnipiac poll, but it doesn't really matter. You look at any of them, all of the deviation on the top line numbers has come from Democrats and independents. The president's approval rating among Republicans has varied in a very narrow band between 80 and 85 since the inauguration. Make of that what you will. But what I will say is, while the president's approval rating on his own party is between 80 and 85, and while districts are gerrymandered to favor districts, and there's a program called Red Map, and again, I don't want to overly pick on Republicans. It just so happens that Republicans won more houses, more state legislatures and governorships in 2010, and the software developed between 2000 and 2010. Computer technology advanced quite a bit, and so in 2010 they were able to use this software called Red Map, where you just feed in the demographics of a district, and it will spit out results that tell you how to gerrymander the district in order to engineer the largest number of safe Republican seats. Okay, so while you have those 2 issues, gerrymandered districts that are safe Republican districts with top-line approval for the president within his own party, members of Congress are more afraid of being primaried by a Trump supporter than they are afraid of losing the general election to a member of the opposite party. That's, in my view, that's the linchpin, the cornerstone that you have to pry loose. Because I think, maybe I'm an optimist, right? I'm a U.S. lawyer. I'm a patriot. I love this country. I think if this were 30 years ago, if this were 20 years ago, you had a president at 36 in the polls, then you would see defections. You would see, when I look back at history, and God, I mean, I grew up as a teenager in the tail end of the Reagan administration, right? Like, that was how I started to become politically active, and I hated Ronald Reagan. I couldn't, but I look back, and there are events, right? Some of the things I remember from history is Republican Bob Dole in the Senate leading the fight to break the filibuster on the Senate floor when racist, bigoted Jesse Helms was filibustering the making of Martin Luther King Day as a national holiday. And Bob Dole, again, Bob Dole and I agree on virtually nothing politically. Bob Dole took to the floor of the Senate and said, this is wrong. This is not about the expenditures of making it. This is about racism, and we should crack this. And that opened the floodgates. And I'm looking for a Bob Dole, and the question is sort of, how do we put in place the structural conditions that can make that possible? I will tell you on a very practical level. Let me give you real pieces. Another piece of unpopular advice but I've already beat up Jill Stein for 10 minutes, so I guess I can go with it. In 2018, again, if you are on the left side of the aisle, they're going to be, the primaries are a great place to vote your conscience. And they're a great place to get excited and get motivated. And I'm going to tell you what's going to happen, okay? I'm going to predict this in advance. And remember, because you can come back and I'm going to say I told you so, the end of 2018. And what's going to happen is the local humanist society in Boise, Idaho, is going to back Star Moonbeam, who is a lesbian, humanist, Wiccan, vegan, and she's going to get 48% of the vote, and it's going to be this amazing turn. But Star Moonbeam is going to lose to a corporatist Democrat who's going to go on to the election. And Star Moonbeam voters are going to be really, really mad at the ex-Goldman Sachs executive who came in and stole the election from Star Moonbeam. And well, we had more supporters, and the J random necktie over here. And I'm going to tell you what I always say, which is, in my view, if you want political change, the primaries are a terrific place to express your opinion. The general election is a place where you use your vote as a very, very imperfect mechanism to get things done. And the folks who get disappointed at Star Moonbeam losing in the primaries and stay home kind of have themselves to blame when J random necktie loses 52-48 in the general election. So that's my big picture and also my kind of on the ground level.
Tracy here.
I was wondering what your evidence is for the proportion of Jill Stein voters who you think would have voted for Hillary.
Oh,
Because, go ahead.
Sure. No, go ahead, please.
Okay, because I've looked and tried to find it, and the only evidence I found was that of the Jill Stein voters, about an equal proportion would have voted for Trump as for Hillary, and the rest would have stayed home. Mm-hmm. And I haven't been able to find anything better than that.
Okay. What's your name?
What is your evidence?
Sure.
Tracy.
Tracy. Thanks for the question. I don't know if we want to go back to, never mind. See if I can go back to the slide. I want to be very clear about what I am saying about Jill Stein and her supporters, which is not that you could have allocated them, which is not that they would have voted had she not been running. It is literally if those people had made a different choice. So I'm making an argument. I am saying if you were a Jill Stein voter in this state and you did not want Donald Trump to be president, then there was a clear course of action. Now, if you wanted something else, hold on. If you wanted something else, or if you don't care that Donald Trump is president in order to get something else, then that's a different result. But what I'm telling you is, if those voters had voted for Hillary Clinton, then Hillary Clinton would have been president. So that's my argument to them.
Did you hear my question?
I did. Right. And what I'm telling you is I disagree with the predicate in your question.
No, I'm just asking you for the information of where your information comes from, because I have some information, and I want
Right.
to know if you have better information.
Right. And so again, I'm telling you, I don't have information that they would have behaved differently. I am saying I think they should have behaved differently. Right.
You mean you don't have those figures?
No,
Right.
the best information that I have
Right.
is that of Stein voters, and also of the Libertarian voters, about the same proportion voted
Right. Yeah, no, I understand the question. What I'm telling you is I'm not answering that question. Right. Right. So I'm not answering that question. I'm answering the question not of what Stein voters would have done. I am answering the question, what should they have done? And that is just the Wikipedia votes from the election. I get it.
What they would have done.
Right, but I don't care what they would have done. That's what I'm saying.
Okay, so if the Libertarian and the Green had not been in the election, the only poll available that I could find said that equal numbers of each would have voted for the Republican and for the
Right.
Democrat. So this would have been a wash.
So I'm going to try and answer this one more time, and then I want to move on. There are two responses to that, okay? So first, when you drill down on that polls, there are a lot of motivated reasoning going on those poll answers, right? Like, I'm very skeptical of the idea that the average Green Party voter's second choice was Donald Trump. Number two, and this is the most important part, I don't care what they would have done. That's a different question. I am not saying I think had Jill Stein not been in the election that results would have been differently. What I said in the speech was, if you were a Jill Stein supporter, if you went out and voted in these states for Jill Stein, the strategy, the optimal strategy, if you didn't want Donald Trump to be elected president, was to vote for Hillary Clinton. That would have changed the results of the election. I am not saying they would have done that on their own. I think many of them would not, and I think they're wrong, and that's why I argue with them.
Okay. In the interest of time, give Andrew a round of applause. Thank you for coming.
Thank you very much.
If you are not coming to brunch and you have a question for Andrew, you might be able to catch him while we're milling around. We have to do some tear down. It takes, 10, 15 minutes. I know Kate is not joining us for brunch today, so there will undoubtedly be people getting there before me. Just ask for the table for Lehigh Valley Humanists. They should be set up for, 20 people. Great. Thank you so much. And thank you. As always, for upcoming events, please keep an eye on our website. That's the best way to stay in touch, and we'll see you next time.